So I think we're going live in terms of the hybrid event. Obviously, hopefully most of us are alive here, and refreshed by the rain in London. So thank you very much, everyone, for joining us here today for this session where we look at the role of settlement and how it might be improved, and potentially the need for enforcement. Really appreciate you being with us today. We've got an excellent panel here for you. I'll introduce them in a minute, both in person and we're truly international, as we're joined by a colleague from Singapore. But before I do that, I wanted to introduce the person who's going to provide a welcome for us, which is Mr. Justice Waksman. We're extremely pleased to have you with us. He is the head of the Technology and Construction Court, and he's also a commercial court judge. It's really important, I think, when we're talking about dispute resolution and the experience of pursuing settlement in London, to have the viewpoint of the judiciary. So, Mr. Justice Waksman, I'm very pleased you're here with us. If I can hand over to you to say a few words.
Thank you very much, Andy, and welcome everyone. I'm delighted to have this opportunity to introduce this very important seminar on improving settlement and international mediation and avoiding issues over enforcement. It is, if I may say so, a vital antidote to the very many sessions taking place this week at LIDW, concentrating on the various challenges facing dispute resolution by courts and arbitration, and indeed comparing the advantages and disadvantages of each, when of course the aim is to avoid dispute resolution by those means altogether. And it seems to me there are two particular aspects of mediation and other non-litigation based dispute resolutions on which I could usefully say a few words at the outset from the perspective of England and Wales. The court may become involved either before or after any settlement has taken place. So far as its pre-settlement role is concerned, as you all know, the learning is now embodied in the amended rules and CPR following the landmark decision of the Court of Appeal in Churchill, which held that civil courts can lawfully stay proceedings for or order the parties to engage in ADR, subject to the provision, of course, that the order made doesn't impair upon the very essence of the claimant's right to proceed to a judicial hearing, and that it's proportionate to achieving the legitimate aim of settling the dispute fairly, quickly, and at a reasonable cost. Accordingly, CPR 1.1F says when dealing with cases justly in the context of overriding objectives, this includes promoting or using alternative dispute resolution. 1.42E says that active case management includes ordering or encouraging the parties to use, facilitating the use of ADR. And finally, 3.120 provides the court can order the parties to engage in ADR. I've no doubt that all of these changes are welcomed by the judiciary. Court of Appeal, in my view, rightly did not seek to lay down prescriptive rules or guidelines as to when it may be appropriate to order a stay for ADR itself, beyond its key finding referred to above, and save that is obvious, any court must take into account all of the circumstances. This is a classic area for the exercise of judicial discretion, which, unless the judge concerned has wholly disregarded the underlying principles set out in Churchill, will not be interfered with by the Court of Appeal if challenged. I have myself been asked on a number of occasions to speak about the circumstances in which it would be right for a judge to order ADR, and I have always declined to do so. There can be nothing more undesirable, in my view, than protracted argument at a hearing about whether ADR should be ordered by the court in the particular case by reference to what happened in other cases or in formal judicial pronouncements on the subject. But I think it's worth noting just what has been said in a couple of post-Churchill cases There's a case called Hayes and Holt, where His Honour Judge Matthews, a very experienced judge, refused to enter summary judgment dismissing the claim. So the claim was going to go to trial. But what he said was, this does not mean that this case must inevitably go to trial. This is a case which cries out for mediation by the parties. I'm aware it's already been attempted and failed. I commend them for trying, but that was before the claim was issued. Now the parties have pleadings and disclosure, as well as this judgment. They should try again, and he will order a stay for that purpose. The claimants will now be aware that on the materials I've so far heard and seen, their case is weak, and the costs of the whole trial would, on the claimant's own evidence, ruin them if they lost. I can also see for considerable scope for cross-examination of the claimants on their evidence. In a case where summary judgment has been sought but not obtained, there's always a real risk at trial for the party or parties that survived that application. On the other hand, the defendant will be aware of the difference between simply looking at documents and being cross-examined. They need to take account of the litigation risk. In litigation, whatever the lawyers say, nothing is certain. And in a second case called Pentagon, also in 2024, the judge held that the claimant had established that the defendant was guilty of misrepresentation, but that was then subject to the proof of loss, which would come later on. He said there could be real difficulties here. He said that he appreciated the last thing in the world that these parties may want to do is mediate yet again. However, perhaps third time lucky. It's quite possible in the context of me having made the determination that I have, and having said the things that I have, it may well be possible for the parties finally to put this litigation behind them. I would actively encourage that process, though I'm not going to order it. And those two cases are, if I may say so, a very good illustration of the proactive approach which modern litigation requires, even if here there was no actual order for mediation. But I want to emphasize, as you know, of course, that the ruling in Churchill and the subsequent rule changes apply to all forms of ADR, not simply to mediation. For example, they would cover court-based early neutral evaluation. I want to say something about that, because I think it's a very underused resource, at least certainly in this jurisdiction. As you know, the process involves a judge being invited to express a non-binding view about the prospects of success or otherwise of a particular claim, or part of it. This may involve consideration of the case on the papers, or by a short oral hearing, usually without live evidence. The hope is that as a result of the view expressed by the judge, the parties will be able to settle the case. However, if it doesn't happen, that judge will play no further role in the case, and unless agreed by the parties, the judge's views will be confidential and treated as without prejudice. In effect, what ENE does is to formalize a process which may already have taken place. Take the example of the failed application for summary judgment that I adverted to a moment ago, an application that fails but only just. In reaching that conclusion, the judge will obviously have said a number of things about the merits of the case, which the parties will take away, or ought to take away, even though the claimant has lived to fight another day. And it's unfortunate, in my view, that the profession as a whole seems reluctant to embrace ENE. The reason I think is not because it's costly, because in terms of the litigation, it isn't, but it's rather because the perception is that when one side comes off worse in the views expressed by the judge, it will adversely affect their negotiating position. Of course, that will follow, but that party would prefer perhaps to have been able to big up their prospects of success in negotiations with the other side, even if the true position is less clear. I understand that reluctance, but I think it's misplaced for three essential reasons. At first, in many cases, the judge's view on ENE can be nuanced. For example, she may indicate that the claimant has a reasonably good prospect on liability, but will encounter real difficulties on quantum. It's exactly the sort of point that Judge Tyndall was making in the Pentagon case. In other words, there may be something for both sides in terms of negotiations going forward. Secondly, much depends on whether the parties want to take, and their clients want to take, a grown-up approach to the prospects of success in litigation, or not. I suspect that many lay clients would in fact want to know what a judge is likely to think of their case at an early stage, irrespective of tactical considerations. Third, and as already indicated, I can see we have active discussion of the topic outside here. Third, and as already indicated, there are various forms of interlocutory application where the judgment on that application will itself contain views about the merits of the case, not just summary judgment, for example, security for costs. So in my view, the parties to a case, and indeed the judge, should not overlook the possibility of ENE being ordered. In this context, it's also worth making the point, and perhaps it will be developed by the panel later on, that where litigation has started and there is a mediation, ENE may become a useful option where part or all of the mediation has stalled because of disagreement between the parties on some point of legal principle, which could be resolved by a view from the judge. Otherwise, there are, of course, cases where the point of principle is so important that nothing less than a full judgment after trial will do. And that, of course, is exactly why the Court of Appeal in Churchill made clear that what the court can't do is to mandate some binding form of ADR, because that would then wholly deprive a party's right to take the case and have it decided by the court. But that said, if the issue of principle involves some novel point of law, it may well be capable of being decided as a preliminary issue without the need for a full trial, unless, which is often not the case, a whole raft of factual findings have to be established first. Of course, the other area where the court may be involved in ADR is after the settlement has been made. Here, the involvement is very limited. It's usually to the approval of a Tomlin order, staying the case on the terms of the settlement, save for the purpose of enforcing the settlement. Since this seminar is concerned with enforcement of settlement agreements, I should say there are obvious advantages to the Tomlin order regime, because if there is a breach of the settlement agreement, the court has the jurisdiction to enforce it without litigating the underlying contract. The downside, of course, is that litigation has to be commenced first, and that wouldn't be consistent with an objective of having disputes settled before they even reach the initial door of the court. I've been asked to say something about settlement rates in litigation. Well, obviously we all know that in general most cases which are commenced do settle, and indeed trials are listed on the basis that the majority of cases listed will settle. But let me say something a bit more specific about the TCC. In the period from October 2023 to September 2024, just over 80% of all claims started in the TCC settled, with 92% of trials actually listed settled. In 2024 to 2025, the trial settlement rate was 84%. Now in the TCC, because cases are given a trial listing date at a very early stage, namely at the CMC, the only cases not covered by those statistics of 92% and 84% are where there's been a settlement after proceedings have been issued, but before the CMC. That does occur, but not very often. We don't keep statistics of the precise stage of the proceedings in which a case is settled. Obviously, many do a long way before trial, but I should emphasize we experience a significant number of cases where settlement occurs only just before the trial starts, maybe pursuant to a mediation which has taken place not very long before the trial starts. Now, you might say that's not a very economic way of proceeding, and I would agree. But it seems that sometimes parties feel that they do not have enough information about their real prospects of success until the case is actually prepared for trial with the full panoply of documents, witness evidence, and experts' reports. Of course, that perception does not mean that the judge should not at least encourage ADR at a much earlier stage. Often at a CMC, I will need to inquire of the parties who have expressed an interest in mediation or have been encouraged to do so, when might be the best time for it. There's then often a debate as to whether one needs to wait until disclosure or even witness statements, and much may depend on the nature and the complexity of the dispute. Finally, let me just say something about dispute resolution of a case where litigation has not started. And obviously what I can say here is very limited, because by definition, the court is not involved unless a contract of settlement has been broken somewhere and it has to be enforced. The first question is how often a contract of settlement made outside litigation is in fact broken. I've not seen any published statistics on this, which is hardly surprising, but I can say that claims made here, which are based on enforcing contracts of settlement which have been broken, are very rare. Indeed, I don't think I've ever encountered such a case, either in the commercial court or the TCC. That is also not surprising, on the assumption that settlement agreements involving a commercial or a TC subject matter are first likely to have been detailed and very carefully drafted. And second, if the underlying driver is to resolve disputes, one would imagine the parties are not going to be inclined to start ones afterwards. But of course, you can't ignore the possibility of a dispute under a settlement agreement. And particularly where there's been a cross-border dispute, the parties will have to agree as to how any breach of the agreement is to be dealt with. The first question will be whether it should be by way of arbitration or court proceedings. The second question is where, as I suspect here, there will be cases which will specify the High Court in England and Wales, just as there are many underlying commercial and construction contracts which favour this jurisdiction as the place to resolve those disputes. Well, I think those high-level points probably constitute quite enough from me. Thank you for your patience, and I'm now delighted to turn to our esteemed panel.
Thank you very much indeed, Mr. Justice Maxwell. That was very enlightening. I now want to just introduce the rest of the panel. I'll start with myself. I'm Andy Rogers. I'm part of the leadership team here at CEDR. I'm a mediator, and I'm also involved with the setting of standards for mediation, both with the Civil Mediation Council and the International Mediation Institute. We're joined online by my colleague Tat Lim. Tat is a mediator and a barrister based in Singapore, and he's been involved, as we'll hear, with the creation of the Singapore Convention. And he's also, importantly, the chair of the International Mediation Institute. Then sitting to the other side of Mr. Justice Waksman is Kelly-Coutinho Stricklin. Kelly is a barrister with 39 Essex and mediator, and she is currently chair of the Civil Mediation Council. Next to Kelly is Sara Ellington. Sara is a partner with Waksman, Farley, Williams. And next to Sara is Wolf von Kumberg. Wolf is a mediator and arbitrator, former in-house counsel, and he has managed the feat of being simultaneously based in London, Washington, DC, and Abu Dhabi. And so we're extremely glad to have everyone with us. I'm going to invite Tat first from Singapore to say a little bit about his view on settlement and the role of the Singapore Convention and the International Mediation Institute.
Thank you, Andy. And first of all, morning to everyone in London and from wherever you're joining online. It's a very good warm afternoon from Singapore. I thought it would be germane to the topic at hand for me to say a few words about the Singapore Convention, given that I actually practice from the home of the Singapore Convention. And maybe from there, speak about just a bit about what I believe to be a development that is important for all of us who are ADR practitioners, but particularly all of us who are mediation practitioners in the age to come. But first of all, I think insofar as the Singapore Convention is concerned, right now, as we speak, I noted that the number of signatories have reached 58 states, with 18 states ratifying the Singapore Convention. And that's very laudable, even compared to the New York Convention. But I think one has to perhaps start the journey by asking, how did the Singapore Convention come to be? Looking at the myriad of literature out there, the one that I think speaks most to me are articles written by Stacey Strong. Professor Stacey Strong used to be a professor from the University of Missouri. She has, in the last few years, I'm not sure whether she's still there, practiced out of the University of Sydney. And she was one of the non-governmental observers who attended the working group 2. She has given a view that the birth of the Singapore Convention could, she thinks, be traced back to a public meeting of the US Department of the State's Advisory Committee on Private International Law, which was called in February 2014 to discuss potential topics for the future work involving the UNCITRAL Working Group 2. And then that saw the presentation of an article that undertook a dispute resolution system analysis of the international commercial dispute resolution regime. That particular article, which was written by Professor Stacey Strong, concluded that there were certain inequities in the legal environment surrounding international commercial mediation that tended to push parties towards arbitration, despite business communities' increased interest in mediation. And she then took the view that the reason for that perhaps would be because of the absence of an international treaty supporting the enforcement of mediation and settlement agreements in a manner that can be found in the New York Convention, and that, in her view, was most likely cause of the underutilization of mediation in cross-border business disputes. This letter suggests that perhaps the best way to encourage the use of international commercial mediation would be to strengthen the legal framework surrounding international commercial mediation by creating one or more international treaties that supports international commercial mediation in the same way that the New York Convention supports international commercial arbitrations. After that meeting, the idea was then refined by the US Department of State's Office of Private International Law through consultations with scholars and practitioners in the field. And it subsequently resulted, of course, in a formal proposal being made by the US government in 2014 to UNCITRAL for a new instrument on the recognition and enforcement of settlement agreements arising out of international commercial mediations. And then, as we all know, the deliberations continued over the next 4 years, which eventually produced what is then called the United Nations Convention on International Settlement Agreements resulting from mediation, or in short, the Singapore Convention. I think it's also germane to note that in the preamble to the Singapore Convention, it states, two of the preamble actually speaks to me about perhaps the premise of the Singapore Convention and the objective. One of the preamble talks about the recognition of the value of mediation as a method of amicably settling disputes arising in the context of international commercial relations, and that the working group and UNCITRAL, and in fact the General Assembly, was convinced that the adoption of a convention on international settlement agreements resulting from mediation that is acceptable to states with different legal, social, and economic systems would complement the existing legal framework on international mediation and contribute to the development of harmonious international economic relations. And so I think all of that leads us to where we are today, a convention that has come into force and have been ratified by 18 states, and I think more to come. And I think the future is going to look very exciting for those of us who are involved in ADR, and particularly those of us who are involved as mediation practitioners and as mediators. I think this is also the point where I look a little bit into the crystal ball and ask, what would that future look like for mediation practitioners, and in particular, perhaps those of us who practice mediation of international commercial disputes? I think one of the things that stands out when you purview the Singapore Convention is that whilst many of the articles perhaps reflect a parallel of what you can find in the New York Convention, the article that stands out perhaps most, and perhaps most unique and bespoke to the Singapore Convention, are the two articles that you will find in Article 5, 1, paragraph E and F. And those are the articles that, of course, talks about two of the vitiating factors where a ratifying state, the competent authority, could refuse to grant relief to a party that applies for enforcement of an international mediated settlement agreement under the Singapore Convention. And those two provisions speaks about breaches by the mediator of standards applicable to the mediator, and standards applicable to the mediation, as well as questions relating to mediators' impartiality and independence, and failing to disclose anything that may have a material impact or undue influence on the party. Those two provisions are, to me, salient and important because it also leads us to examine and consider what might be an important element in terms of the mediation that we find across the world today, and what maybe would be a useful way to think about, should there be a discussion on what sort of standards should apply to the conduct of a mediation and the practice of a mediator in this context. And it leads me to wonder that perhaps in the international environment that we find ourselves, the only institution that I think has been doing work in this area where the work transcends local jurisdiction is perhaps the International Mediation Institute. The IMI is, in my view, the only organization in the world that has developed global professional standards for mediators and advocates involved in collaborative dispute resolution and negotiation. And certainly, I think we look at the mission of the IMI, one of its key mission is to set and achieve high mediation standards. And what that means is that in terms of IMI, its raison d'etre, one of its primary objective and the key for its existence is that IMI exists to create standards for mediation worldwide, where its appraisal committee provides qualifying assessment programs, which in turn certifies mediators and mediation advocates on these established standards, and therefore enhancing the practice of mediation and improving consensus and access to justice. I think this is a vision that should appeal and excite all of us who are involved in this area of work, because I think setting high standards and standards that are accepted universally and certainly worldwide is an expression that should find its way into the work we do. I think this is, to me, a very exciting time for mediation practitioners. And before I hand this back to you, in Singapore at least, all of us are immensely excited by what the Singapore Convention has done to improve and enhance the landscape of mediation. But I think it'll be worthwhile for me to close my opening with just a note that was spoken by Chief Justice Sundaresh Menon. When he observed the Singapore Convention, he said this, right, that he was confident that the adoption of the Singapore Convention on Mediation would herald a new era for the resolution of cross-border commercial disputes. Just as New York Convention did for arbitration in the 1950s, the convention will unlock the potential of international commercial mediation by removing what has perhaps been the greatest obstacle to its ascendance. And he says that in the coming decade, he believes that as the global economic order continues to reorientate itself towards Asia, he believes that we will see the sun rise over a new golden age of international commercial mediation, unquote. And it's on that very positive and optimistic note, Andy, I will stop my address and hand this back to you.
Thank you very much indeed, Tat. Hopefully we'll have time for some questions at the end, but I think one of the key principles of LIDW is that we finish on time, and we have a lot of interesting views to hear from. So we'll hold the questions for the end, hopefully, which means that it's now time to move on to our next speaker, Kelly, who's going to talk a little bit about lawyers and dispute resolution in relation to settlement.
Yes, thank you so much, Andy. This is an interesting topic. I am here as chair of the CMC, but also I'm a lawyer. So for me, this is an interesting topic. I just want to pick up on something Sir David said around the judiciary now being proactive, because we have these additional powers, we have the infrastructure for ADR to be something which is used in the best way. And for my part, that means that as lawyers, we also have a responsibility to look very carefully at what methods of dispute resolution we're using and how we can best assist our clients. And I would just reflect on this. As lawyers, we are all very used to using methods of dispute resolution alongside the traditional parts of litigation that we're used to. So we're all used to Part 36, to writing closed correspondence, and all of those sorts of things. But I think the time has now come to set aside some of the notions we might have around the appropriate time for that being after certain stages have happened, or it being something that you use in little doses along the way. Realistically now, because we have the infrastructure, proactive judiciary, and the ability to use dispute resolution properly, we should be really using it as one of many tools in our toolkit as dispute resolution practitioners. Okay, and my perspective is looking at where you might be able to use this or these types of skills. There is no stage in the litigation process where you can't use this. It may be that it's appropriate now to use mediation much earlier. I certainly see a lot of pre-action at the moment. The difference and the changes in the rules has meant that some solicitors, at least that have come to me, have said, well, we know we're going to get to a stage where probably we have to consider this. So let's think about it as early as we need to. And when I say every stage, I do mean that. I'm sure that there are good reasons to go to court, for example, if you want to dispute costs bill, but that strikes me as exactly the sort of area where you can realistically and sensibly save yourself some court time. So there is something here around the continued use of dispute resolution methods alongside your litigation work. And I would also reflect that there's something interesting here about method, because there are different tools for different types of issue. We often talk as mediators about the balance between commercial issues, legal issues, and personal issues, which all come up in different ways. And the behaviour of the parties in your case may also reflect what method is the right one at a particular time. I mentioned Part 36, and I think sometimes it has the effect of putting the other party a little on the back foot, quite deliberately. And that can be a very helpful tool in the right moment. Equally, close correspondence can be very helpful. Just giving you an example where you might use it in a fairly adventurous way. For example, if you're working with a public body on the other side and it's a question of whether a decision has been taken properly, one of the things I've certainly seen is providing in closed correspondence the draft evidence and to say these are the reasons we will say your decision has been done wrong. Now that is a very classic legal thing to do, but there is a place for all of that type of work still. I would just then reflect on what the wider landscape now looks like, dispute resolution. And again, to pick up something Sir David said, the idea that we can now mix methods of dispute resolution is really exciting. The reality is, if you can use, for example, if there is a need for having liability or a steer on liability to get the parties a bit further towards resolution, then of course E&E is a great way of doing that. And you may even do things like have a determination on liability and have quantum dealt with separately and so on. So I think there is something here about a newfound need for flexibility on our part as lawyers to think about what is the best way of doing things at each stage of litigation. I'm bound to say it, I appreciate I may be a little biased, but in my view, mediation does provide an additional benefit, which is I think a little bit different to many of the other methods, because it does allow for true creativity and it allows for resolving a dispute outside of the context of merely the legal issues in front of you. And I think particularly where you've got, say, parties which have complex relationships or a web of relationships, then that can be a particularly suitable way of doing things. But I think just to sum up, the key thing for me is around designing the process. And what lawyers should be thinking about, in my view, is what the factors are that are relevant in this particular case. So is this kind of thing where the commercial aspects are more important and therefore you need to focus on those? Is it one where actually the legal arguments are really quite important, but you need perhaps to get that resolved and have a little bit more of a discussion on some other aspects and so on. So it's about that. It's about timeframes as well and costs. And I would also just observe, finally, it may perhaps be something to do with the type of dispute resolver that you need. So you will see across our panel different types of people with different types of experience and expertise, including from the very beginning of the process of perhaps even pre-action, looking to Wolf and going more towards the final determinations.
Yeah, I think Kelly and I had a discussion before we started. And I told her that I'd been involved in a number of facilitated negotiations. Well, mediation, of course, is a form of facilitated negotiation. But, I come from an in-house practice originally, and There were many situations where we would negotiate with the other party, but I felt if we'd had a neutral involved in it and we weren't just discussing it directly from a positional perspective, that it would have been helpful. And I've had a number of occasions now where lawyers have asked me to facilitate the negotiation between the lawyers in the sense that I would act really as a chairman of the discussion. So we would agree an agenda, and I would then be involved in a meeting where a particular matter was being discussed and an attempt was being made to negotiate. And so it's different than the mediation process. It's not as formal. We did have an agreement as to what that process would look like. And it was actually very beneficial because the lawyers felt that they were able to deal with the discussion, having somebody there as a neutral to assist. And so that's something that where mediation may not yet really be contemplated, or sometimes people feel mediation is too formal a process, just bringing in a neutral to help with the negotiations could be useful.
I think in structure, if I may, Andy, just to pick up as well on some of Mr. Justice Waksman's comments about people waiting because you don't really feel that you know what the real prospects of success are. I think what you do know at the outset of a litigation process is what the real prospects of it taking up loads of time, loads of money, dragging out for absolutely ages. And certainly I find with my clients that are litigating a lot, they really understand what the kind of commercial as well as monetary cost of going through that process is. So actually I do find certainly with those clients that they're much more willing to mediate a lot earlier. And I've also had some very successful mediations where there's parties that perhaps don't litigate all the time, but the mediators have really spent a lot of time at the beginning explaining to the parties, almost really letting the litigators on each side go at each other a bit at the beginning of the mediation, to give the parties a taste of what the alternative is like, and really kind of building that conversation in, I think, is a great way of kind of bringing it to the table a bit earlier.
Thank you. I think we'll move on to my comment. So I wanted to approach what it would be like for a disputant from outside of the UK to come to London with their dispute. So I've come up with a mini Lonely Planet guide to coming to London with your dispute. And I think the first thing to say is about the environment here is we do stand on the shoulders of those who came before us, because they have 25 years ago created an environment that we benefit from now in terms of Lord Wolf's Access to Justice report and the following civil procedure rules changes that created an environment where there is an expectation that people will look at reasonable conduct and there are sanctions for failing to do so. And it put mediation within the settlement front and centre in terms of views on and attitudes on looking at how we would resolve disputes. And I think moving beyond that, whilst there have been various bits of helpful adaptations to the civil procedure rules and case law, etc., as Mr. Justice Waksman referred to, not least the fact that in the pre-action protocols, you have to demonstrate that you've considered alternative ways of settling your dispute prior to trial. We are now in an exciting new chapter where we have the Master of the Rolls has been very supportive of alternative ways of settling, and as has Lady Justice Carr as well. So it's things are signalling well for the future. But I think what's key to understanding settlement in London is two things. for me particularly. One is, as Mr. Justice Waksman so clearly put in relation to the TCC, most cases settle before decision at trial, and that's a reality. And the second point is that mediation can help you get there. And one of the things that people who haven't used mediation before are often amazed by is what the one of the founders of CEDR, Karl Mackie, has called the magic of mediation, which is the fact that once you start engaging with the process, even if you came without the intention of settling, things can shift because the process explores both parties' interests, it reality tests, and it does that from every conceivable angle. So as has been said, actually, when you get to the point of a settlement, it is one that both parties are bought into, which obviously has implications for enforcement as well, because if parties have looked at something from every angle, then the need to enforce is not so high. One of the Mr. Justice Waksman was mentioning the fact that there's no settlement, there's no figures on a number of settlements that need enforcement. There was an anecdotal statistic that was floating around over a decade ago, which was in settlements from mediation, it was 3 in every 1,000 that needed enforcement, which I think would speak to the scarcity that you were talking about. But unfortunately, I can't actually substantiate that. What I can say, though, is in relation to settlement and frequency of settlement in mediation, is that even when it is directed by the courts or mandated, then the statistics show and we don't have a huge track record of it in this jurisdiction, but from other jurisdictions, that there are good chances for settlement. So whether it be in Ontario or Poland or Kazakhstan, where there is some form of mandatory mediation, then they will be the settlement rate, I think, forgive me if there are any Polish people in the audience, I believe that the figure in Poland is slightly worse than 50%, but not a lot. And it goes up to 60+%. So you have a half or better than half chance of settling your dispute, even if you're made to go to mediation. And for those who voluntarily come to mediation, my colleague Graham Massey was very kind enough to share a preview of the CEDR mediation audit, which in combination with the civil mediation council counts the number of mediation cases happening in the UK. He hasn't given me that number, but he has told me that the settlement rate is just under 90% of cases settling on the mediation day or in the short period afterwards, which I think that reflects, I think, the fact that we don't currently have mandatory mediation, and at least not beyond the online small claims. That figure might go down slightly, but when people voluntarily come to mediation, as we were saying when we were talking before, Mr. Justice Waksman, when people want to settle, they will settle. But also if people are given a window to settle and it's within the scope of what they want, then that's likely to happen. I just wanted to also just talk about kind of expectations when coming to London with a dispute, both for people here domestically, but particularly internationally, and to tell what for me is a scandalous story, which I'll try to anonymise as much as possible. So about 15 years ago, I was asked to speak at a in-house conference on mediation at a Magic Circle firm. It was on mediation in Russia and the former Soviet Union. So I talked a bit about cross-border disputes, about how different jurisdictions had been developing mediation as part of their civil justice landscape. And after I'd spoken, a partner got up from the firm and basically said he didn't think mediation worked. And for him, it didn't work because he said, my clients from Russia and the former Soviet Union, when they when they come to London, they want to fight. They don't want to mediate. They don't want to talk, and therefore I'm not going to propose it to them. And I'm not going to propose it to them because, firstly, it's not in the best interest of my firm, but more importantly, it's not what the clients want. And for me, I found that shocking, both in terms of it was a view that you rarely hear openly, but also he was being brutally honest. But I think the thing that really kind of saddened me that kind of view could exist is the fact that he's not giving his clients the best possible service by explaining to them that there is a route that would give them something differently. Obviously, that it is important that people have the right to fight if they want to fight, and even in a mandatory mediation, when you're forced to walk through the door, and you might even be forced to sit at the table, you're not forced to make an offer, and you're certainly not forced to accept something that you're unwilling to accept. So I think for me, and I also very clear that that is a view that happened 15 years ago. Whether or not it would happen today, maybe, maybe not. But I think the optimist in me wants to say that the groundwork that we have has given a good environment here in London for people to be able to settle their cases, both in terms of the civil procedure rules, the flexibility in processes, but the fact that mediation is readily available. The pessimist in me says that changes still needs to behave, and that's about it's about education, but it's also a little bit about time as well. As I said, the difference between 15 years ago and now versus the difference between 30 years ago, maybe we're in a different world. So I think that's my Lonely Planet guide to coming to London. Well,
And if I could just add to that again, coming from an in-house perspective, what we did to overcome that kind of obstacle, particularly with respect to outside lawyers, was to build a mediation provision into our disputes clause. So while there's an argument that may be too early for mediation because it requires you to mediate before you go to arbitration or litigation, the point actually is well made, and that is that once people get into mediation, they may come there reluctantly. So they've agreed originally when they contracted to have mediation. So now, in a sense, it becomes mandatory because it may be several years later that they actually get to that point. Management may be different, people in the firm and the company may be different, but they are then required to mediate before they can go on. And the lawyers are required to mediate before they go on. But the magic there, and I saw it many, many times, is even if you have a reluctant party that comes to mediation because of the process, they do often settle. So I think that's a point for corporates is to really look at whether you include mediation in their disputes provision.
thank you.
And just to clear up for anyone who's visiting London, who's not England or Wales qualified or online, as a solicitor, part of your duties is actually to act in the best interest of your client. So obviously, you know, this particular law firm partner felt very vehemently that they were doing that at the time. But I think, you know, all of us have kind of got to the end of a very long litigation process, getting a judgment which probably isn't everything that you hoped for. I mean, even if you win often, the underlying ratio isn't great. Maybe you're going to then have to go off to the appeal court. Maybe you won on part of it, but not another part of it. And so, you know, I think we need to reflect ourselves. This strange dichotomy that we have whereby we all became dispute resolution lawyers or litigation lawyers because we actually really love trials. And we'd really love for every case to go to trial. But ultimately, that's pretty much in most cases not going to be the best outcome for the client, and certainly has that big risk element in it. So we do have that duty, just in case anyone was unclear.
That dichotomy is actually quite challenging, to be fair. I sometimes find that when I'm mediating, as a mediator, I think in one way, and when I'm a lawyer, I think in a different way. And it's a challenge because we do want to litigate. We're good at trials. We like doing that sort of thing. But it is about having that range of different skills within. And if I can just also add on the point around where we are system-wise in the UK. So we've obviously got things in the CPR, but at the moment we've also, don't forget, got quite significant backlogs in some of our specialist tribunals and so on. So I'm just reflecting on the recently published statistics on, for example, the Employment Tribunal, which has a really, I think, at the moment, the biggest backlog it's got. And the changes that were made to the civil procedural rules don't apply in specialist tribunals at the moment. And that's something that we at the CMC have been having some discussions around, you know, is this an area where actually these powers should also be implemented into the specialist tribunals too? And we had a conversation earlier, well, fairly recent, I can't quite remember when, Graham, a few weeks ago, around one of those specialist tribunal systems, and that there are in some of them, like the tax tribunal, ad hoc schemes to help a use of ADR. But I would just observe that perhaps that isn't the case in every single specialist tribunal, and the tax tribunal is quite a good example where it works quite well.
Thank you. I'm now going to pass over to Sarah, who's going to talk a little bit about institutions and settlement in relation to those.
Great. Well, thanks, Andy. And I suppose I feel like mediation has kind of followed me the entirety of my career. So I did my first mediation as a party advocate in 2008, and just as I was finishing off my training contract. And at the time, that was very much a strange thing to be doing. Like there weren't a lot of mediations ongoing in the firm, but throughout the kind of years that followed, more and more mediations all of the time. And I feel that kind of as that has tracked through, there's been kind of more and more institutions that have been putting out the rules across different jurisdictions. So we've got some really great kind of base institutions now, and certainly also institutions that across different jurisdictions and legal systems are also putting out these kind of tiered dispute resolution clauses, like you mentioned, in standard form that you can incorporate in contracts. So I feel, and Andy, I know that you've got a good international view of this, and you might say some things afterwards, but we're in a place where we've got that kind of really good basis about knowing mediation and knowing its place within the disputes context. And what I'm finding now is that I'm actually seeing institutions thinking about a lot more about how we prevent disputes. So I'm actually doing quite a lot of work as a dispute resolution lawyer, trying to put myself out of business and not having any disputes to resolve. Essentially looking at things in a much more relational way. And there's two particular examples that I'm very close to that I wanted to share with you. In terms of what institutions are doing to try and put together this kind of landscape of facilitated negotiations, as you mentioned, but also kind of ongoing project and transactionals. So one of these is something that Wolf was involved in drafting rules for. It's called a Conflict Management Committee. It's been put together by an institute in the Caribbean, which essentially looks at putting in place a kind of cross between a dispute resolution board, let's say, that you might be familiar with in a construction context, and a project-based mediation, essentially looking at big infrastructure and extractive projects, and having a kind of independent third party both supporting the parties to contracts for these types of projects, but also the communities. So essentially they have that ongoing relationship with the communities and the parties, and they can keep that dialogue going, but also act in a more kind of structured mediation way if necessary. And another scheme in a slightly different context, I put together for a Dutch foundation called Legal Innovation for Sustainable Investments Foundation, which essentially looks at putting in place a long-standing neutral party to facilitate impact investments. And again, that brings in the third-party stakeholders as well. So I think we're seeing a lot of innovation in the space, and hope to see more of that going forward.
Thank you. I would, and thank you for mentioning the kind of international context, because a lot of CEDR's work internationally involves looking at development of mediation. So we're now at a point where globally most jurisdictions, most countries will have some form of mediation law, and the often the torchbearer for that for mediation in that country is a local possibly Chamber of Commerce, arbitration centre, will also be a mediation centre. But there's huge variation in terms of both in terms of the law and what the law stipulates, but also the culture around that and the willingness to use mediation. What I would say is that certainly in CEDR's perspective, when you go back to a country 10 years after they establish their mediation centre, they might not be very busy, but they probably won't have closed. There will be work that's happening there. It's just possibly not as much as they would like, unless they actually enact some form of mandatory mediation. So I think that's very encouraging, and it means that there is more knowledge of mediation and what that means, and therefore some of the understanding in terms of what that means in relation to settlement as well. What I would say is that London is one of the better environments in terms of what we've been able to set up here. So in terms of if you have a choice of where to go, obviously that can fittingly be a strategic choice. With this particular dispute, I want to name this as the seat at which I want it resolved, and therefore I'll also look at settlement as well. London's a good place to do that, but there is also more general awareness of what settlement is, but it's a little bit of a lottery depending on where you are in the world.
One thing we might mention, because obviously this week is also about arbitration. And there have been, I think, a lot of interesting innovations through the institutions in the way of the use of mediation as well. So the American Arbitration Association, the AAA, actually now mandates mediation unless parties opt out of it. So if you're going to file an arbitration notice with them, they will first ask you whether you have mediated. If you've written the AAA into your provision, then you've basically opted for mediation. So, and many parties don't actually realize that until they come to file, and then they're asked whether they mediated, and they're told that they have to mediate before they can actually proceed. So that's an interesting, I think, almost mandatory then requirement. I think the ICC has done quite a bit too. They issued a guidance on settlement and international arbitration a couple of years ago now, but it has some very innovative guidance for arbitrators as to building in mediation windows in their scheduling. Also, quite radically, as Mr. Justice Waksman spoke about the INIs here, it basically does the same thing for arbitral tribunals, where a tribunal is asked by the parties or might suggest to the parties, and they consent. They can give a non-binding view of where they think the arbitration is at a particular point in time. I think that's something that probably continental arbitrators like the Swiss would quite readily do. Probably you find some reluctance from certainly English arbitrators to do that. But in any event, you can see that the arbitral institutions also are thinking about ways mediation can be brought into the settlement process.
Thank you. Which I think leads us now to you, Wolf, and you're going to. I've already forgotten about what you were going to say. I was so dazzled by your last comment.
Enforcement of mediation.
Yes,
settlements, although that's been discussed already, I think, to a certain degree, but I think as Tat started with the Singapore Convention, maybe we do something the Singapore Convention, because that clearly the intent of it is to create a forum whereby cross-border mediated settlements. So that should be a cross-border commercial matter, cross-border commercial mediated settlements have a way now of being enforced, similar, as I've said, to the New York Convention for Arbitration. And the intent is that parties then are able to take their settlements to the state where they wish to have enforcement, and that the court of that state would then enforce it as if it were a judgment of the court. And I think, Tat, I mean, are there 58 signatories now to the convention? Is it 58? And 14 have ratified? Is it 14 ratification?
I think 18.
18, okay, right. So it changes all the time, but so we're seeing more and more countries, certainly at this stage, far more have signed and ratified than the New York Convention. The New York Convention took some time before it really took off. So I think there is a prospect there for the potential of having an international mechanism to enforce mediated settlements. The UK actually has signed, has not yet ratified the Singapore Convention. Interestingly, and I think this is a flaw actually in the convention, but and that is that states can take actually there's a reservation provision that they can reserve not to have the convention apply to the government itself, which appears, rather odd, given that the state has signed a treaty that recognizes mediation, but they can reserve it. So I know that Saudi Arabia and Qatar, for example, who were early, the early entry into the Singapore Convention, they both have taken that reservation, which I think, in a sense, defeats the purpose. But in any event, to convince people in a cross-border situation to mediate, you can say, well, there is an enforcement provision potentially. Now, whether their states have actually signed it or not, that's another question. So we've got that. I think we've already heard that, I mean, generally, and this has been my own experience too, where there is a mediated settlement, the parties themselves have decided that that's what they like to do. And so in most cases, parties will then comply with the settlement simply because they've entered into it. Now, there may be the odd situation, as Mr. Justice Waksman referred to, where he does then have to go to the court. But here, I think the Tomlin provision is actually useful if the matter is already before the courts. If it isn't, then of course you're going to have to try to enforce it as a contract that's been breached. So that's much more difficult. One of the jurisdictions where I've been active the last few years is the UAE. And in the UAE, actually, they have a new mediation law, which provides that these would be domestic mediations. Those settlements can be enforced by the courts as if they were court judgments. So that's another example of where a jurisdiction has chosen to help enforce mediated settlements through the court system without having to then go through a breach of contract dispute. I think there are perhaps other ways that parties can think about enforcement, maybe as part of the settlement agreement itself. There could be a provision that would allow for a speedy enforcement of the settlement. One area that I've been involved in is investment disputes, so through ICSID. And one of the areas, ICSID has mediation rules now, so they're encouraging those types of disputes, investment disputes, investor-state disputes, to be mediated as well. An interesting development there is that there is quite a bit of interest in utilizing mediation post-award there. So there is an award, but one of the issues now for investors is then enforcing that award against the state. Increasingly, states have been reluctant to actually pay their awards. And so utilizing mediation at that point in time to structure the payment of the award is having a lot of interest. So while that doesn't go directly to enforcement, it provides at least a vehicle whereby the award can then be dealt with. So I guess
I wanted to perhaps just to say something here, because not being particularly familiar with the Singapore Convention, but of course the difference between enforcement there and enforcement of an arbitral award under the New York Convention, or indeed enforcement elsewhere of a judgment, is that usually the judgment of the award is going to be pay this amount of money. It might be more complicated, but very often it isn't. And that's very straightforward from the point of view of an enforcement mechanism. And we do this all the time in arbitral awards, where the rules provide for us to make sure that there's nothing odd about the arbitration agreement, or there isn't going to be some objection that can be made, and then otherwise you make your judgment. In a mediation, of course, as Kelly has mentioned, there's a relational aspect, and the settlement agreement might be quite a lot more complicated than simply pay the money, particularly if you are trying to make use of the fact that the parties did have a trading relationship and actually they got on pretty well and there's a future trading relationship. So you get all sorts of clauses about placing orders, what they want to do in the future. Now, it strikes me that there's an irony here, because I agree that if the settlement agreement is pay X, it's going to be pretty unusual, having settled that and having made that agreement, the relevant party is then simply going to turn around and say, well, I'm not going to do it. I mean, they might, and they might just be disingenuous. There's far more likely to be a dispute if you have these complicated provisions and one party says, well, I've performed all the other things that you've asked me to do in your trading relationship. And the other party says, no, you haven't. Now, to bring that under the convention before a court is then actually going to be quite a complicated process, because it's going to be quite difficult for the court to make an order that isn't some kind of mandatory injunction. And all I'm throwing up is that the areas where you might actually find someone purportedly not complying with the mediation, the settlement agreement, are precisely the areas where you may run into difficulties over enforcement.
That's a good point.
Yeah, and particularly perhaps where I'm just reflecting on times I've had to draft terms and settlement agreements at 10 PM potentially in this building.
Yeah.
They're never quite going to be as pristine as you would like them to be in the cold light of day.
I think one of the great things about the kind of flexibility of mediation is the ability to almost have a second bite of the cherry, including with hindsight, about your law and jurisdiction clause, and where it is that you want to enforce your mediation agreement. Because, you know, as litigators, I'm sure we've all opened up a contract that's been sent to us previously, and looked at the choice of law and jurisdiction and just been like, why are these particular parties with assets in these jurisdictions chosen English law and jurisdiction, for example, for their dispute? Because, you know, there are certain jurisdictions in which you know that it's going to be very difficult to enforce English court judgment, perhaps even very difficult to convince the courts there to apply English law, even if they hear the dispute themselves. But when you're in a mediation situation, actually, again, you have the flexibility to draft the settlement agreement however you want. You can include then the correct law and jurisdiction, having done your research about where the assets are. So you're almost doing it again with the benefit of hindsight. So I think that is a great strength of mediation, and you know, something that is helpful. And I think the Singapore Mediation Convention is helpful for that as well, from an English and London disputes perspective, particularly because of the types of states that have already ratified it. Are some of the states where actually it's most difficult to have an English judgment. recognised.
And I think as well, it speaks a little bit to, certainly for this jurisdiction, as we've talked about, the need for enforcement is rare. And so, and I would say in countries where the need for enforcement is rare, signing the Singapore Convention is about sending a signal about the maturity of mediation, because I think it's more likely that you will have a signatory to a mediation settlement go bankrupt or cease trading, or but deliberate non-compliance with the settlement contract is in my view pretty likely to be rare.
Just one other kind
Yeah,
of question to the panel, if I may, which is that, you know, we know that mediation has the possibility to take into account all of these other kind of commercial aspects. And obviously during the training to become a mediator, there's a lot of focus put on that kind of interest piece. And is there a continuing relationship, certainly in the mediations that I've been involved on both sides of the fence? We almost have a bit of a chuckle about that, because most of the time people don't want a continuing relationship, and it really is just about money. So, I mean, how many of these kind of difficult to enforce mechanisms do you really come across in practice?
I had some quite interesting ones recently, which have involved all sorts of things I wasn't expecting, because they look quite commercial as issues. You know, things like apologies and public statements, which are in a sense quite easy because you just do the thing and it's done. But then there have been some kind of interesting relational ones where, as I've been listening to what the parties are saying they want to do is their relationship going forward, in my mind I'm thinking, gosh, how's that going to be written down, and how's it going to be workable in future? And for my part, I think that really relies on the goodwill of the parties actually wanting to do it and getting them.
Because Mr. Justice Waksman said, I mean, that's where the difficulty lies when it comes to enforcement. And that's the whole, I mean, the beauty of mediation is that it can lead to a commercially sensible settlement. But, you know, sometimes, and I've seen this where as the mediator, you come to a conclusion and there's a framework for the settlement there. The lawyers have to go out and then draft that. And then you find that there are difficulties because, you know, the understanding that let's say the commercial people have, you know, is sometimes, as you say, Kelly, difficult to translate into a legal document.
Could I add a thought to that, Andy?
Yes, I was just going to say, Tat, well, we haven't heard from you for a while, and it would be good to do so. And then I'm going to ask the same of Mr. Justice Waksman, if he had anything.
So could I maybe just offer two thoughts on this? I mean, first of all, hearing what Mr. Justice Waksman was talking about in terms of say a mediated settlement agreement, might that prove difficult to enforce if it's anything other than payment of money, for instance? I think the wise counsel would probably look at how the terms are structured and recall or remember that under one of the grounds of relief, the settlement agreement which is sought to be relied on can be deemed or can be judged by a court to be incapable of being performed under the law to which the parties have validly subject that agreement to. So you bring forward that discussion, you ask yourself that relevant question before you put it as a term of the contract. But of course, providing for a proper law of the contract or governing law, then it would be the law that's deemed applicable by the competent authority of the party. And so in terms of the guidance given by Article 5(1)(b)(1), I think there's enough there to provide the council with enough thought process to say, well, if I'm going to construct an agreement which is enforceable, well, where would I enforce it? And, you know, in that jurisdiction, is it likely that I can get what I want if parties will perform? I mean, take, for example, in Singapore, there's actually legislation where a judge can order a party to provide an apology to the other party, unheard of in many jurisdictions. But I think a clause that says apologize A to B would be something that a Singapore court may be receptive to enforcing. You know, and we can talk about the utility of that, but, you know, depending on the jurisdiction for which the enforcement takes place, you might find some very interesting orders being granted to the party seeking to enforce a mediated settlement agreement. The other thing I just want to close also to say is, a lot of these thoughts that we've had relates to legal structures of mediation. But I think a lot of users are probably going to ask themselves, like, why mediation? I mean, what's the magic, we call it sometimes? I think one of the things we haven't spoken about is that the reason why I think mediation has worked, there's a rich array, increasingly even more so, of neuroscience which supports this, and lots of literature. But I'll just simply say very quickly three things, right? First is that the literature shows that when people go into mediation, what mediation does with a great mediator and a mediation advocate, it activates the mirror neurons in us and the empathy through this structured dialogue that we have. And what it does is it enables the oxytocin to be released, and which fosters then trust and openness. So that's one. The second aspect is this idea of mediation. People do storytelling and narrative. Again, that's something which is very organic to the way human beings work, right? We like to tell stories. We like to tell our version. And what mediation does is, with an experienced mediator, he helps to construct a shared narrative that helps parties to synchronize, to co-create an outcome that they can live with. And then the third is, again, back to the physiology, right? That when you think about mediation, it helps to lower the cortisol level of all of us, so that parties going to a mediation where there is, a very organic way to sit down, have a drink, and be comfortable, it reduces these uncertainties, restoring agency and providing this emotional support, all of which makes for problem solving, a more effective problem solving process. So I think one mustn't forget that this is the way that human beings like to resolve conflict. In my experience, having spent 35 years practicing in disputes, I've really not come across clients who say, that they relish an experience of being cross-examined by someone, being beaten down, and at the end, saying that's the best experience. A lot of clients who go into trial feeling very optimistic often come up with somewhat mixed feelings. And so I'll leave it at that. But I think the utility and how it's based on science should not be overlooked, as we discuss why mediation is effective. Back to you, Andy.
And thank you for reminding us that we have brains that has chemistry going on in them, and that the actions that we take can impact that. So I think we'll open the floor to questions in a minute, but I would like to hear from Mr. Justice Waksman, who's heard us hold forth on various different elements in terms of any reflections he's got.
Thank you. I'm going to be very brief. I just really want to make 2 points. And of course, my perspective, because I'm a judge dealing with litigation, is my encounters with mediation and ADR in the context of litigation. Two points. First of all, timing. In many disputes between commercial parties or construction parties, it may well be that the case is going to settle at some point in any event. Where I think mediation can assist is enabling that to occur at a much earlier stage before significant costs are incurred. I remember 20 years ago speaking to someone who did construction disputes and talking about settlement, and he said, well, my dear, of course we'll settle it, not till we get to the court door. The implication being, of course, he'd like to earn his brief. Now, we have moved on from that, but so the timing of mediation is really important. And what can we do about judges? More than I said earlier on, I'm not in favour of staying a case at a particular stage for 3 months for mediation, where otherwise nothing is happening in the litigation. I think it's much better to have a timetable where you're not staying anything. It's just that there's no further thing to be done for 2 months. But at the end of that 2 months, there is something to be done, whether it's disclosure or whether it's witness statements, because the parties then know, if the idea is they're going to mediate in that window, but if they don't, then a very costly exercise is about to kick in. And that's where I'm actually quite proactive, and I quite often will set timetables bearing that in mind. A very good one, which often works, is where the relevant stage, which has to be completed before the next one, and you hope there's a mediation window, is Christmas. And the last is Christmas, and then people go away and they have some time off and they just think about things and reflect on it. and it very often works. That's timing. Second point I wanted to talk about is where the judges can be proactive. And I've given some examples, but sometimes the reason why judges need to be proactive is not because they're just actively pushing mediation or because they're generally talking about the risks involved for both parties. It's because they detect that there are failures of understanding on one or both sides. And I don't mean because the lawyers are silly, of course they're not, they're highly intelligent and skilled, but because litigators by definition are operating in a silo for the most part, and they are, however much they want to be sensitive to the weaknesses of their case, there can quite often be situations where I can see that they're just not understanding the context of the dispute. They're actually missing something. And provided you can do it in a sensible and fair way, there's no harm in reminding them of that. And what's important is that the clients are actually there to hear that. And I did a very big and complicated dispute, whose details I won't reveal, but it was very much in the public eye some time ago, and was heading for a trial. And I could see there was a point on each side which they hadn't really thought about, or they hadn't thought about sufficiently on the implications. And in the course of a heavy interlocutory application, and I made carefully worded observations to each side to remind them of that. And not long afterwards it settled. Now, I'm not claiming the glory for that settlement. There may have been many other factors, but what was interesting, and I've never had this before as a judge, is that at some conference, probably some event like this, I had representatives from the solicitors from both sides who said, what you said to us then was really helpful in bringing about a resolution to this. So what I try and encourage as head of the TCC is for judges to be a bit canny when it comes to all of that, if they can understand how the parties are working or not working. That's all I wanted to say.
No, thank you. And thank you also for explaining why I almost always get a mediation 2 days before Christmas. Any questions? Frankie, if we have a question online, or we can take one from online. But so yes.
Yes, I'm Peter Field. I'm a barrister at the Barrister Group in the UK, and also just published a book on effective dispute resolution. Picking up a question from Mr. Justice Waksman on early neutral evaluation, which had its origins in 1985 as a North Carolina study, which showed the real effectiveness of doing it. And it's not really, I don't see it used very much in the UK. So the question is why and how could it be encouraged? Secondly, more importantly, perhaps, is that study, the 1985 study, concluded it should be used as early as possible. I'd like Mr. Justice Waksman to comment on how early is early as possible.
I mean, you can have ENEs which are not done by judges, and quite often people will be aware of this, so the dispute might not have got to court. And there's different forms, and some arbitrators or mediators will actually be prepared to act as early neutral evaluators. So I mean, if we're talking about that, and that seems useful, then obviously I would suggest that's a tool which could be used and can be used even before the litigation starts. If it is after the litigation has started, then it's got to be sufficiently progressed for the real issues to be identified. Because if you don't know what the issues are, it's absolutely hopeless, unless you're going to use the blunt instrument of commercial negotiation, in which case you won't want an ENE or even a mediation to begin with. In my judgment, seeing it, because we have case management conferences very early, the earliest you could possibly do it is when the statements of case, the written arguments of both sides have actually been produced and they can be considered. I think that very often parties overestimate the value of the disclosure, saying we don't want to do anything until we've had disclosure. And I think as a judge, because I have to look at a case at an early stage, I can get a feel for where the issues are and where it might end up pretty early. So to answer your question, and particularly since the CMC takes place before disclosure, well before witness statements, but after the issues have been ventilated, and some initial disclosure has been given, then it's something which can and should be canvassed in an appropriate case at the CMC, just as you would mediation.
Thank you. Yes, the quick, sorry, Hugh, behind you. Yeah.
Yes, coming back to the title of this event,
Yeah.
which is including certain international mediation, then the bit in brackets, and avoiding enforcement. But I'll be frank with you, that last part is what enticed me here. I just wonder if the panel could give some tips about how to avoid enforcement in international mediated settlement.
Check the liquidity of the parties prior to starting the process. Any other thoughts?
I have to confess, I wasn't sure what that meant. And I understood it to mean avoiding issues over enforcement. In other words, if you have to enforce it, making enforcement easier, but I may have got that wrong.
Any other thoughts?
I mean, I think that obviously, particularly when you're representing a party, you are doing everything to try and avoid issues with enforcement. And therefore, I'm doing everything to try and make sure the other party can't avoid enforcement. And for me, that means, you know, really properly preparing for a mediation. In terms of things like making sure that you've got a report on the asset position of the other party, as you say, Andy, knowing what their liquidity position is. So, you know, quite often in a mediation, you'll have someone come out and say, well, actually, I can't afford to pay for judgment, otherwise I'll go into liquidation. Well, if you've done your research beforehand, you'll know whether that is really the case. But you might also be able to find out, for example, whether there's any personal guarantees, whether, you know, that if that insolvency position does happen, the directors are going to lose their house because it's going to be enforced against that. And kind of going into the situation, being prepared, knowing where the assets are, knowing how easily you can or can't enforce against them, means that you're able to put on the proper pressure points. So I certainly think, you know, as with everything around mediation, kind of going into it, being prepared, having thought about all of the different angles is going to get you a much better outcome.
Okay. Thank you, Sarah. I think St. Paul's is shortly going to tell us that we're out of time. So Frank, if there were any questions online, if we can make a note of them and we'll get back to them after this event. But as I said, the cardinal rule of LIDW, because there are so many events happening, is to not go over. So if I could just ask you to join me in thanking the panel for giving their time, and thank you all for attending both online and in person. Thank you.